Welcome to the program. My name is Marty Schenkman, and I'm joined by my colleague, Alan Gassman. Now you see us. He's definitely much more handsome than I. This is part two of a two-part series on asset protection for physicians. The first part, if you missed it and want to see it, can be found on schenkmanlaw.com/webinars. It's been posted along with the materials. You should download the materials from this the handout section on the console. We're using the same PowerPoint for both the first and the second installment. Don't hang up if you didn't hear part one, because this will be largely independent and you'll be able to follow just fine. So we're just trying to cover a wide topic that's critically important to so many physician clients, asset protection. And we're not going to cover all the slides, even between these two parts, but there are great materials, and Alan deserves credit. He created the slide deck. So thank you to Alan for that. Let's get started. Let's advance the slides. Keep going. So let me first, it's kind of become my practice that every webinar that I host, I try to promote a different charity, because there's lots of good we can all do in the world. And we'll have a word from the American Cancer Society.
Thank you so much, Marty, for the opportunity to be on today's call and for all you do to support our organization. My name is Jennifer Cayetano, and at the American Cancer Society, we are activists, we deliver breakthroughs, we build communities, and we provide direction. We're attacking cancer from every angle, through research, direct service, public education, and behavior change. Please review the slide included here and visit our website at cancer.org to learn more about the important work we do in local communities across the country. Thank you again, Marty, and to all, and may you enjoy the rest of the call.
One of the things you can all do, and I encourage you to do it, it's a good deed and it'll take you literally a minute, is if you go to cancer.org /NPAN, which stands for National Professional Advisor Network, you can join the Professional Advisor Network for the Cancer Society. They're not going to solicit you, but you'll get some very informative emails about charitable planning and invited to a number of good webinars they do during the course of the year. Great organization, good cause. Next slide, and we have as a sponsor Peak Trust Company, and let me introduce Peak by saying, because it's absolutely appropriate for this program, I don't just talk about asset protection. I believe in it, and I practice it myself. In 1998, within I think 6 months of Alaska passing the first domestic asset protection trust statute in the country, I created a self-settled trust for myself and my family in Alaska, and I have it to this day. Strongly encourage you, if you are a physician or an individual listening to this call, speak to your advisors. If you're an advisor and looking for a trust company to partner with, Peak is one of the companies that I work with and have my own trust there. Peak, Nicole?
Hi, thank you, Marty. My name is Nicole King, and I'm a trust officer at Peak Trust Company. We're pleased and honored to be able to sponsor today's presentation. I'd like to take this opportunity to tell you a little bit more and kind of piggyback what Marty said about Peak already. Excuse me. We have offices in both Alaska and Nevada. We are a full-service trust company, and we offer flexible and customized administrative services for all types of trusts. We welcome you to visit our website at www.peaktrust.com, and feel free to reach out to any one of us, and we'd be happy to discuss what we can do for you. And with that, I'll turn it back over to Marty and today's presenters. Thank you.
Thanks. Tom, let's advance to slide 39. That's kind of where we left off after the first installment of the program last Friday. And we're going to pick up here and talk about what is really the heart of asset protection planning. We're not going to cover the remaining 100 slides in today's presentation. Alan will lead the show and we'll jump around to some of the different parts. We are going to take some time and belabor the next few slides, because this is really essential to the kind of planning that you want to do to protect a physician client's assets. Alan, why don't you lead it off, and I'm gonna interrupt you as we go, because I think this is just great slides and a really critical part of the whole plan.
Okay, and I think one thing to mention on the outset is a lot of people ask me, how do you deal successfully with physicians A lot of people find them to be difficult clients. And one thing that I always do is I make sure that the client has a visual picture of what I'm trying to do. And I make sure that I go at the right speed so that the client does not lose what I'm saying. Because a lot of non-physician clients will not understand what you're saying, won't tell you they don't understand what you're saying, and then they just don't want to go forward. With a physician client, they're more likely to tell you if they're not following you, but if you go visual with them, you can have much better results. So here's a typical scenario, and this becomes a multiple choice exercise because you have spouse one, they typically have a revocable trust because they heard about avoiding probate, whether that really means anything or not. That's where the guts of their estate planning documents are. They typically have a simple pour over will that pours the assets into the trust. But you don't want them to put any assets in the revocable trust. Because if spouse one is the doctor and spouse one gets sued, under state law in most states, if not all, everything in that revocable trust is accessible to creditors. So for example, if that doctor is a Floridian and he owns a cash value life insurance policy, an annuity contract, those assets are creditor protected until he puts them in the revocable trust. In Florida, Delaware, Idaho, a few other states, just about anything that a married couple can own can be held as tenants by the entireties. And in those states, if one spouse is sued, then the creditor cannot touch the tenancy by the entirety's assets. The creditor needs to get a judgment against both spouses. Otherwise, if the creditor even gets a judgment against spouse one files bankruptcy, the creditor can't touch the tenancy by the entirety's assets. The judgment goes away in bankruptcy. Spouse one and spouse two retain their joint assets.
Let me add a couple of comments. So I live in Connecticut, which doesn't have tenancy by the entirety. So our home is actually owned by an LLC owned by some of the irrevocable trusts that Alan's going to talk about because there is no tenancy by the entirety. My wife and I have let's call it a vacation home in New Jersey. New Jersey has tenants by the entirety. So we own that outside of the trust exactly as Alan said, jointly because there's a measure of protection. So you need to be very mindful, what does the state law where you have a property or the asset and where you reside provide for, and you need to plan accordingly. I would just be a tiny bit less extreme, and I'm sure Alan won't disagree. I do keep assets in my revocable trust. I keep a bank account, a small brokerage account, because I do want assets there. I pay my bills out of it. I live out of it. And it never has large assets for the reasons Alan said, but I keep some assets there. And the primary reason I do that is I think a revocable trust is a phenomenal planning tool for disability, which is not the focus of our presentation, but that's a way you can kind of accomplish both goals. There's sort of a middle ground there. Alan?
Yeah, good point. Now, if spouse two is not a physician, let's say spouse two is a soccer coach at the local high school, then it would make sense to put assets into spouse two's revocable trust so that if spouse one gets sued, spouse two has these assets and they are protected. But remember, if you or your clients are in a community property state, which includes, of course, California and Texas, if these are assets that have come about during the marriage in the community property state, the creditors of spouse one can attach them no matter how they're titled as to whether they're in joint names or in spouse two's name. So you may have to transmute out of community property status in order to protect them. Also, you're going to want to make sure that spouse two has at least $5 or $10 million of umbrella liability insurance for all driving and other activities that could cause loss. And we're going to talk in the next slide about using subsidiary LLCs.
I'm a little, Alan, I'm a little more skeptical and paranoid perhaps and worried about the legal system than Alan. Even if I have a spouse who's not a physician, and by the way, even though we're focusing on asset protection planning for physicians, lawyers, accountants, people on boards of directors, people sitting on charitable boards, there is huge liability exposure almost everywhere you look. And the litigious nature of our society worries me. So what Alan is depicting is a very common approach to planning, and frankly, the way a lot of clients, especially physician clients, may start. If the spouse is not a physician and isn't perceived to have great liability, having assets in that spouse's name is something that's done. My suggestion is that you really, if you're going to really protect yourself, you really want to go further, and we're going to get to that in some of the other slides. And I would try to protect the assets of both spouses because, and Alan's mentioned it, and he's one of the few lawyers that ever seems to talk about it, it's not just the complex esoteric stuff like a malpractice suit, it's driving. It's kids having a party and too much booze and something happens. So I would consider very carefully going further, although this is a great first step.
Right. So then the next circle is the irrevocable trust that they can make transfers to that would benefit only the children. They can use their $15,000 a year exemption and make gifts to this trust. And on slide 40, we'll talk more about that trust. And then the last circle on the right is what we call a lifetime bypass trust or a SLAT. And Marty, you want to talk about the SLAT now? Because there it is.
Yeah, and folks don't get confused by names. A lifetime bypass trust is a great descriptive term because it's kind of like the old credit shelter trust. You're just setting it up while you're alive. It's often called a spousal lifetime access trust because I set up a trust for my wife and all descendants. That is the core in many cases, and there's a lot of variations, and we'll talk about some of them as we go through this, but that is the core of the planning. Why so? Because if the physician is married and the physician transfers assets, and you want to make sure it's not a fraudulent conveyance, we talked about that last time, and you'll document it, to spousal lifetime access trust for the spouse and all descendants, and then the non-physician spouse, because I like to protect on both ends, transfers assets to a spousal lifetime access trust for the physician and all descendants. The family can transfer a substantial amount of wealth out of their name, but each spouse is a beneficiary, a discretionary beneficiary of the other spouse's trust. And in that way, they can still theoretically have access to 100% of the wealth that they've transferred, but it's protected. Alan?
Yes. So typically, the high earner spouse is going to feel somewhat comfortable putting assets into the SLAT on the far right-hand side, even though that spouse is not a beneficiary of the SLAT. An alternative would be to put the SLAT in Nevada, Alaska, or one of the other creditor protection states, and provide that in the unlikely event of a divorce or in the unlikely event of spouse one's financial fortunes reversing terribly, that spouse one could be added to the SLAT as a discretionary beneficiary in the discretion of trust protectors. As Marty said, each spouse could fund an irrevocable trust for the other, and if you follow the tax court decisions and the IRS opinions on this, you can make the two SLATs different enough so that they will not be uncrossed for federal estate tax purposes. But we don't know whether the reciprocal trust doctrine might apply in a broader way for asset protection trust and creditor protection purposes. In other words, if I set up a trust for my wife and my wife sets up a trust for me, the IRS may consider the trust that my wife set up for me to really have been set up by me, but they have some fairly reasonable guidelines. We don't know what the guidelines are in the creditor's rights area, so if you're going to be doing this, you definitely want to do it in an asset protection jurisdiction and warn the clients of the potential risk.
Let me interject a comment. Alan's comment is great. Let me give you a visual because Alan's right. It's not even just physicians. Everybody likes a visual. We really have a continuum. On the far left end of the continuum, I can do a fairly inexpensive spousal lifetime access trust, naming Uncle Joe as the trustee, maybe name Aunt Jane on the other spouse's trust, so they're different trustees, and do it in the home state for the client. On the other hand, if you really want a better level of protection, and it's really what I've done for my own family, and it's what I favor for clients unless there's a strong reason not to, which usually relates to the size of the estate and the money that can be afforded at this time. I prefer to put both slats in different asset protection jurisdictions, one in Nevada, one in Alaska, for example. And that way, I have different state laws apply, which helps differentiate them, as Alan said. It's also harder to pierce, and it's using an institutional trustee, which is harder for somebody to prove there was any implied agreement between the client, the physician, and the trustee when it's an institution. And you can go anywhere in the continuum in between in terms of cost and complexity, but I really prefer to get far down to the right end of that spectrum. Before you go on, Alan, Tom, somebody complained by email that they're not seeing the slides. Just make sure the settings are correct, that the screen's being shown. All right, we can go on to the next slide. Alan?
Okay, so slide 40 is the same as slide 41, except now I'm showing subsidiary entities. I'm showing this, and this is a really old slide, so I'm showing family limited partnerships. I should really update this to show LLCs, but they pretty much work the same. So, for example, instead of putting most of the investment assets of this couple under tenancy by the entireties or under spouse two's revocable trust, I can put this wealth into family limited partnerships or LLCs owned mostly in tenancy by the entireties, mostly by spouse two's revocable trust, but in small part by an irrevocable trust for the children. And the reason I do that is because now under Florida law, or the law of most states, if you got a judgment against both spouses, you would not be able to reach into a limited partnership or an LLC owned 3% by a trust for the children and 97% as tenancy by the entireties by the spouses. And one big reason for the trust for the children is that the gifting trust you see there does not need to file an income tax return if it's properly drafted. It is what we call disregarded for income tax purposes. And in my opinion, when a married couple, even TBE, own an LLC or partnership 97%, and 3% is owned by a disregarded trust that they've set up, I don't think they have to file a partnership tax return. So they could make one of their children a 3% member or an uncle or an aunt a 3% member. Then that FLP is going to have to file a Form 1065, and that'll cost thousands of dollars over the long run. If this is a relatively small client, they probably don't want to spend that kind of money on tax returns. The instructions to the Form 1065 says that a TBE couple is supposed to file a partnership tax return. The Bloomberg B&A portfolio on this topic, I believe, accurately says they don't need to. And there's a rev proc that I can send anybody who asks, which says that there would be no penalties. But again, spouse two now, the soccer coach's assets are much better protected because of the charging order situation. Let me mention, your clients may not live in a charging order state. For example, California allows a creditor to take the LLC or partnership interest not to be limited to a charging order. But if you have half of the voting rights held by the gifting trust and half of the voting rights owned by the spouses or by spouse two revocable trust, then the creditor can't outvote. And even if they get ownership, they can't reach anything and they can't force a distribution. Marty, any comments on that?
Of course. So let me use the same idea of a continuum. On the far left, if the client is younger and their assets aren't so great, but they want to start like a physician that's new in their career, just building wealth, I think it makes a world of sense for young physicians to start this planning. One of the biggest mistakes I see with physicians is when do they start their asset protection planning? they go to a lawyer after they get sued. Little bit late in the game. Not necessarily too late. That's not what we're talking about now, but it's late in the game. I encourage young physicians to start their planning right away. So a young physician with more limited resources and more limited wealth to protect, having the tenants by entirety, a revocable trust, which is simpler and easier and cheaper to create than a complex trust, maybe having a local state slat, all makes sense. Maybe they have an SLP, but they don't do the firewall LLC, which we haven't talked about, but we will. But you can move down that continuum. Further down to the right of the continuum, which I think is more the place that a physician concerned about liability protection wants to be, is I would set up the non-reciprocal slats, as I said, in jurisdictions that permit self-settled trusts. We now have 19 of them. So if something goes wrong or is misadministered, that's a great fallback position. Even if it's a slat, it has that protection. You may not want to do a large trust or not even any trust for the children. You may just do the two slats in better jurisdictions. Having an FLP or an LLC that's owned by the various irrevocable trusts so that no trust owns more than 50% is a great way to accomplish what Alan said. So again, there's a continuum of where you need to go. And I think that's really important for physicians, because you're not going to be able to get a young physician with limited resources that's just starting out to be willing to go the full length on the spectrum. However, if they start now where they don't have claims, their assets are more modest, and they start making gift transfers once every year or two to a trust, by the time they start to accumulate wealth, slowly over many years, they could have transferred a lot of that wealth into the trust structure. And by making transfers each year of more modest amounts, it may be far less susceptible to an attack as a fraudulent conveyance than if the physician who's been very successful finally shows up at your door and makes large multi-million-dollar transfers. So again, apply this very flexibly depending where the physician is. Alan, before we go to the next slide, you should explain the firewall LLC, because that's a really important concept.
Right. So in the middle family limited partnership, they may have brokerage accounts and rental properties. I sure don't want to have brokerage accounts in the same entity as I have rental properties, because tenants slip and fall and sue, and children eat paint chips, and sick building syndrome causes people with asthma to go to the hospital and maybe die. So I always want to have an LLC or other entity as a firewall to own the property or the activity that is high risk. So this client may have a securities portfolio and a 10-unit apartment building. That 10-unit apartment building may be worth $1 million. I would have that owned under the firewall LLC, and I would have the firewall LLC owe the FLP maybe $750,000. So now if there is a horrendous nightmare situation, the firewall LLC gets a huge judgment against it. It sells the building for $1 million. The creditor gets $250,000, and the FLP gets $750,000. When you're dealing with plaintiff lawyers representing tenants, and they see that there's debt against the entity, and they see there's no assets other than a little bit of equity and the limits of liability that the insurance carrier has, they're much more likely to settle for the limits of liability without delay. If you have left this plaintiff lawyer with the possibility of getting personal assets, it is much more difficult for them to settle the case, because their client would like to have not only the limits of liability, but also the exposed assets. On the far right-hand side, spouse 1 donated to the Lifetime Bypass Trust for spouse 2, but is a control freak. I'm sure none of your clients are control freaks, and I know I'm not one, and I know Marty's not one either. But spouse 1 could be the manager on a fiduciary basis of an LLC owned by that slat, so that spouse 1 can control the investments. And spouse 1 can have the right to replace the trustee of the slat. So really, spouse 1 has a lot of control over the slat, just exercisable in acceptable conventional ways.
Couple of quick comments. So I would actually say every client's a control freak. We all like to be in control. but it's a philosophical conversation. Sometimes, and we're not going to get into the great detail of it, but sometimes by giving up what seems to be superficial control, you can get, in effect, more fundamental control because you're protecting your assets better. So depending the nature of the control piece the client wants, I may suggest to them that they may be better off from an asset protection perspective having somewhat less control. So that's a discussion to have. Now, what I do with a lot of these underlying FLPs and LLCs, and let me make a comment again using this continuum. For a young physician just starting out, they may just have assets in the trust. As they start to make a little more money, you may have the trust drop the assets down into an FLP and have other assets contributed. You can create these structures. They're flexible later in time too. So encourage the young physician to plan and start doing asset protection planning, because the sooner they start, the better. And you can always graft the planning Alan talked about on later. What I like to do now, moving further down the continuum for a wealthier physician looking for stronger asset protection, what I like to do is, as we said earlier, I like to create these lifetime bypass trusts or SLAT in one of the self-settled trust jurisdictions like Alaska or Nevada. I would try to form the LLC or the FLP in Nevada. If the client lives in New Jersey, then have it authorized to do business in New Jersey if, in fact, there's anything in New Jersey. And the reason I do that is I think having the LLCs formed in the state where the trust exists is another way you can create greater nexus to the jurisdiction, because now you have a Nevada trust and Alaska trust owning an Alaska LLC. Alan?
Very good. Let's go to page 44. This is something that I recommend you consider for your married clients where the non-physician spouse may die, and then the physician spouse is going to want to fund a asset protection trust because they no longer will have the protection of tenancy by the entireties or the ability to put assets into the name of the spouse who died. Well, transferring assets to an asset protection trust at that time might be considered to be a fraudulent transfer if you're unfortunate enough to be defending a malpractice suit or have a situation like that, and to have lost your spouse all at the same time, and that does happen. So consider having your client sign a legally binding agreement which says if spouse 2 dies, spouse 1 agrees to put any joint assets, any assets inherited from spouse 2, and a certain other additional amount without delay into an asset protection trust. That way, spouse 1 is doing this not to avoid creditors, but to comply with the terms of the agreement with spouse 2. It's just an idea. Go ahead.
What Alan's pointing out is a very clever idea, but let me just reinforce how important it is, the issue that Alan's addressing. The most common form of asset protection planning I see by physicians and lots of other clients is too simplistic and almost foolish. And what is that? If I'm a physician and I'm worried about liability, and my spouse is, what was the phrase you used, Alan, a soccer coach with no liability, I just put all my assets in the non-risk spouse's name. But I have seen way too many cases, and Alan has too, where the soccer coach spouse gets in a car accident, gets sued, does something wrong, is on a board of directors. You got to be very careful. And the biggest fallacy of I'll put it all in my spouse's name because my spouse is not a doctor is, well, what happens if that non-doctor spouse dies? So that the big expensive house that's worth millions of dollars with no mortgage on it now is owned by me because it was in my spouse's name and it comes to me, or it was joint ownership to take advantage of tenants by entirety. Spouse dies, now I own it outright. It's an exposed asset. So the simplistic approach to planning is not really smart. And this is one clever way to deal with it. But my recommendation is go back to some of the planning we talked about earlier. Protect both spouses from the get-go. Alan?
Let's go to slide 47. Now, this is a non-married physician. There's no spouse to use tenancy by the entireties. So we want to make sure that this physician understands what is protected from creditors. In some cases, on the left-hand side, of course, you've got the IRA, the 401k. Many states will protect variable or or fixed annuity contracts, which can be a very good alternative to bonds for investment purposes because you defer the income tax until you take it out, permanent life insurance, and in some states, a wage account. If you live in a state that protects the wages of a physician, then usually there's protection of that money when it goes into a wage account, and then from the wage account to another creditor-exempt asset, which might be an asset protection trust in a different jurisdiction. So this individual may come to us and have $300,000 of money in his name completely exposed, and he saves $150,000 a year above and beyond his expenses. His wages are protected from creditors in the state he lives in. Well, I'm going to have him bank his wages into a variable annuity contract, into an asset protection trust, into life insurance contracts, and let him spend down his $300,000 of exposed assets. There's nothing in the fraudulent transfer law that says you can't spend an asset that would otherwise be exposed to a creditor on normal living expenses, and there's nothing in those laws which says that you have to spend your assets such as wages that are protected from creditors. So when you sit down with the client's CPA and the CPA says, well, I'm going to pay this client $250,000 in wages so he can max his pension plan, or $280,000. Let's pay the other $400,000 of dividends. Well, wait a minute, dividends are not protected from creditors, and if the company is considered to be insolvent because there's a nasty malpractice action against it, then the dividends you take out may be recouped by the creditor and may be a breach of fiduciary duty for the doctor to be paying himself such large dividends. So this is where you may want to have the wages be at the actual fair market value of the doctor. Now, this particular doctor has a living trust. In most states, the living trust cannot own the practice company. In some states, they can. The doctor does not want to go through probate, so you have her own the medical practice entity directly, but have her sign a conditional assignment of ownership, which is held in escrow at your office, and when she dies, you assign the ownership to her successors. They convert the company to a non-professional corporation, and probate is avoided because you've prepared one nice sheet of paper. To the right of the practice corporation, I have the building or equipment entity. Now, if the building entity has $800,000 worth of debt owed to the bank, secured by a mortgage on the building, I'm going to check and see if the bank also got a guarantee from the practice company and whether the bank got a security agreement so that there is a pledge of the furniture, equipment, and accounts receivable of the practice entity towards the building mortgage. So now if there's a horrific judgment against the practice entity, it can liquidate. The bank will take the first $800,000 worth of assets, and the plaintiff lawyer will have a hard time wrestling the bank away. There is something called the marshaling of assets doctrine. It's rarely used. Then also, I'm going to have a 20-year lease signed between the practice corporation and the building LLC. And that lease is going to say that if the practice corporation ever becomes insolvent or can't pay its rent, that all of the remaining rent is due and payable under an acceleration clause, which may be enforceable in many states. So now the plaintiff lawyer is faced with being second in line to the bank, actually third in line to the landlord, who also has lien recorded against the assets. You see here that I have a gifting trust for the lovely children of this physician. It owns 3% of his securities, LLC or limited partnership. I have an offshore asset protection trust, which owns 99% of a real estate partnership, which owns 3 LLCs. Each LLC owns a separate building. Each LLC owes a note to the real estate FLP based upon about 75 to 80% of the value of the building. Then he has S corporation stock that he's invested in a venture. I warned him not to, and it's probably not worth anything, but if it is in a Nevada asset protection trust, because you cannot own S corporation stock in an offshore asset protection trust, and it's dangerous to own S corporation stock even in a disregarded LLC. You could have the securities FLP own the S corp stock, but then if the accountant accidentally files a partnership tax return, or someone other than the client makes a contribution to the securities partnership, it is no longer disregarded and you lose the S election. It can make you very unpopular. And then on the right-hand side, this doctor's parents formed a trust for him. They named him the trustee. He's able to get what he needs for health, education, and maintenance. And under laws of the states that use the Uniform Trust Code, his creditors can't reach into that trust because it was what we call a third-party settled trust. So, Marty, what are your comments and additions for that?
So keep in mind the concept I've used on many of the comments on the slides of the continuum. You don't need all these pieces, all these different components may not make sense for a particular client. You pick and choose for each physician what they need, and what they need will vary over time. So you may start with, just a few of the icons on a chart like this, but as the physician's wealth grows, you may add on more and more. So it's very flexible, but it does illustrate a lot of planning concepts. One thought that came to mind when Alan said you can spend down reachable resources, one of the ways to really do that can be great, and it's something I actually did, if you convert a regular IRA to a Roth, you spend down reachable assets to pay your income tax. I think it would be very difficult for someone to argue that paying a tax bill is a fraudulent conveyance, and a Roth conversion can be a great way to whittle down exposed assets. And then instead of having an IRA, which net of taxes, call it 50 or 60 cent on the dollar assets, it's 100 cent on the dollar assets as a Roth. Alan?
Yeah, very good. Let's go to page 54 now. I want to mention that obviously when you meet with a physician client, you want to ask what they expect to inherit. And a lot of them expect to inherit a lot. And then you say, well, I hope that it's not coming directly to you. I hope that it's coming to you as trustee of a trust that you can have access to and direct on your death, but that creditors will not have access to. And quite honestly, that can be a real pain to arrange because the parents have different lawyers who may not understand how these rules work, or the parents may not want to pay for it. So what I recommend that you talk to the client about is that you draft the inheritance trust. There's some features on page 56. Say to the client, I'll draft an irrevocable trust. You sign it. You put $10 in it. Then we simply ask your parents to amend their estate plan. Instead of saying 1/3 goes to our beloved son Clyde, it says 1/3 goes to the Clyde Jones Inheritance Trust. And then it's done right. And your client can even have the right to amend that trust up until the parents die and it gets funded or the parents make a gift to it. But do remember, even an inheritance received 180 days after you file bankruptcy is lost to creditors, let alone an inheritance that comes before then, and the issues that you get with whether your spouse is going to have a right to the growth from your inheritances. So my next slide.
Before you go on, just to emphasize, this is such critical planning, and it's so often missed. So often physician clients come and they're focused on, a complex, sexy-sounding irrevocable trust in a state like Alaska or something. They forget some of these fundamentals that Alan just pointed out. I had a physician client, it must have been about 8 years ago. I remember meeting him. I remember where I was sitting at the meeting, and my jaw dropped. He didn't do what Alan said. His father died. He got about a $5 million inheritance. There was a large claim outstanding. The entire claim was lost. The couple of $1,000s that if that physician had gotten done just what Alan said by having the father's will redone could have saved the entirety of the inheritance. So this is really an important point. Alan?
Okay, let's go to page 61. I know we have a lot of accountants and insurance professionals on this call, and I want to just point out to you that almost every physician that we represent that has drafted their own operating agreement for an LLC or has had their accountant or their friend or LegalZoom or whatever it is draft their operating agreement has fatal flaws in it, which could cause loss of an S election, loss of the ability to have what we call the charging order protection that a creditor can't reach in, loss of tenancy by the entirety's status. You cannot be too careful when you draft or when you review client operating agreements. Don't just get them off the internet. It's probably okay to get porn off the internet and maybe other things. It might even be okay to form the LLC, but that operating agreement has to be dead on right. Let's go to page 66. At page 66, I want to point out that confidentiality can be very important to a physician client. This slide really refers more to how you hold rental properties to protect them from liability and also get insurance on the building. But in these scenarios, we have many clients who have their homes in a land trust with a Wyoming or Colorado or Delaware LLC as the trustee of the land trust, so that the property records show the LLC as the owner and don't show the individual as the owner. And Florida allows that and even allows the homestead exemption to apply outside of the purview of what the public can see. So we want to talk about confidentiality here for your physician clients. It may not be important as a practical matter. It may only be important to them. But if you search SUNBIZ, Alan Gassman, you don't even have to go, if you search that on Google, you don't even have to go to the Secretary of State website. It will automatically take you to every company that I'm an officer of. So you want to show that to your clients and explain to them that they could set up out-of-state LLCs in states that don't reveal identity, have those LLCs be the managers of their LLCs, and that way they have their confidentiality. And by the way, my gosh, if you're going to own a rental property, don't ever put that property in anyone's personal name. They are huge liability attractors. Let's go to page 72. As I said, I know there's a lot of financial professionals on this call. Feel free to share the article here that includes page 72. Homes are very rarely a good investment. They lose their value because they get older every year. When you hear that the median home in your area has gone up by 3.5%, that's not your home. Your home is a year older now and the roof is leaking. And your mother-in-law lives there because you have too many square feet. So we just want to make sure clients know, even if the home is a protected asset, it does not necessarily do them a lot of good from a financial standpoint. Let's go to page 86. At page 86, many people still don't realize that a defined benefit pension plan or a cash balance pension plan can allow a middle-aged physician to put a lot more money away on a tax-free basis with very little going to the staff. So even a 45-year-old who can only put $56,000 in a profit-sharing plan or a 401k could additionally put $113,000 a year in a defined benefit plan or $123,000 in a cash balance plan. So we have a census form on page 88. I don't need to review it with you now, but you should know to make sure that you have a competent pension plan actuary, not someone who went to a class for a day, not someone who studied this in law school 9 years ago, an actuary with a good computer program. They can tell you how much you can put away for your client. And under the new Tax Reform Act, it used to be the deadline for starting a plan was December 31st. Now it is when the income tax return comes due in the following year. So you have more time than you used to have, but you shouldn't waste any time on this. Page 99. Again, I know there's a lot of financial professionals here, but at least for the lawyers, keep pages 99 and 100 near your conference room. Take our names off of it. When clients talk about estate planning, one question I say is, Dr. Jones, do you have life insurance on Mrs. Jones? And Dr. Jones will often say very little. And I'll say, you realize if you die, you're going to have child care expenses. You're not going to have Mrs. Jones to put your assets name under. And you might also be depressed and not want to work as much. Why don't we get $1 million policy or a $5 million policy on Mrs. Jones? And they say, what'll it cost? Well, a 15-year, $5 million policy will cost $4,000 a year. And if Mrs. Jones dies, you'll be in much better shape. Your creditor protection will be much better. Mrs. Jones will know that her children will be taken care of because she'll know that you're not going to remarry and leave everything to the next spouse. Now, yes, it is up to the insurance professionals to help the client decide what kind of insurance to buy. But if they have decided at minimum they're going to buy 10-year term life insurance because they've looked at my chart, they know they're fairly healthy, then I can start drafting my trust documents to accommodate life insurance without having to wait for the client to go meet with the insurance professionals. That way we've got some momentum. When they get to the insurance professional, they already can tell them, I've got a trust going, I need to get moving on this.
Let me add a couple.
Sure.
So when you're looking at insurance, let me just, we're not going to move the slides, but just think back to the spousal lifetime access trust, lifetime credit shelter or bypass trust that we've spoken about is the core of many of these asset protection plans for physicians. One of the issues is if I set up a trust for my wife and descendants and my wife sets up a trust for me and descendants, if my wife dies prematurely, I don't have a means to directly access the trust that I created for her. So there's certainly things we can do. You can look at hybrid DAPs, you can look at SPATs, you can look at loan provisions. There's mechanisms legally to draft into the spousal lifetime access trust to try to address my wife dying prematurely so I can get at the assets. On the other hand, a very simple way to do that is to have my wife add a couple $1 million of term insurance into her slat for me so that if she dies prematurely and I lose access to my trust that I set up for her, there's extra money in her trust to compensate for that. And a lot of times, if you get some financial modeling done, what you'll find is once the clients reach a certain age, they'll have enough assets in the other trust in their own name that they won't need it. And you may very well be able to use a term insurance policy in many cases to supplement the SLAP plan and address the risk of premature death. Helen?
Yeah, very good point. Okay, let's go to slide 122. And by the way, there's a lot of slides in here. I hope you'll read them. Let us know any questions, but there's also a slide about buy-sell agreements. I sure don't want a medical practice to own life insurance on the life of the doctors, because if one of them dies, the practice gets a big check, it gets sued for malpractice, it's all gone. I don't even like the doctors to own the life insurance on each other under cross-purchase. I like a trustee cross-purchase or a separate entity purchase. And there are slides that discuss that. Now, page 122, this is what we see all over and over again. We do several of these every year. You've got the medical practice on the left-hand side. It's got all the valuable equipment. It's got accounts receivable. Oh my gosh, it's even got the building. And you ask the client, why do you have all these important assets in the practice? And the accountant will typically say, I was told by my accountant or by my lawyer that I could not move them out. Well, the accountant or lawyer were not thinking about Internal Revenue Code section 1.368F, as in Frank, the new parent F reorganization. We've written several articles on these, and I'll be glad to share them. All you have to do is set up a new S corporation and make that a PLC or a PA if required under your state law. Then make that the 100% owner of the medical practice S Corp, which becomes a Q sub. You make a Q sub election. Now, the medical practice can keep its name and its taxpayer ID number. It can keep its Medicare relationships, its managed care relationships, its Medicaid relationships. This is not considered to be a change of ownership. It's considered of the assets or of the practice. It's simply a change of ownership of the entity, which is very easy in most situations. Now, the new parent company establishes brother-sister companies. They can be Q subs or disregarded LLCs. One can own the equipment. One can own the real estate. One could even own the accounts receivable. Now, when the medical practice gets sued, there's a lot less exposed. The third section of this shows you the possibility to factor accounts receivable. If you have clients that are experts having to do with the treatment of personal injury victims, typically these are orthopods, physiatrists, chiropractors, and pain doctors. They don't get paid until a case settles usually, and that's 2 or 3 years. So a doctor who makes $700,000 or $800,000 a year may have $3 to $4 million of private accounts receivable. You certainly don't want to have those owned by the medical practice. So those can be purchased by a factoring company, and the factoring company can be owned by the same parent, so you're not triggering income tax, and it can be financed by a family limited partnership that makes a high interest loan to the factoring company. So the kids, as primary owners of the FLP, are making 14 or 15%, loaning money to the factoring company. The factoring company is buying the more expensive letters of protection and accounts receivable. The medical practice doesn't owe them anymore. You've got a lot of tax reasons for doing this, and you know it's a good thing we have an article on what we call the elope system. Let's go to page 123. Here at 123, I'm just showing you the same thing in a different way. John owns a medical practice. It's worth $1.8 million of assets. Doesn't want to move the assets around. He's got the real estate worth $1.2 million. He doesn't want to go to the bank for debt. So if we go to page 124, we see that the medical practice could owe John or the family partnership up to $800,000, which is the basis of his stock in the medical practice. The CPA says if you owe more, you'll trigger tax. And then the building entity owes the family LLC $900,000. You record a mortgage, or you at least give the practice entity the ability to require that a mortgage will be recorded when the time is right. But how do you get more debt owed by the medical practice? Well, if you go to page 125, you use a new parent F reorganization. The new parent company owns the medical practice, which became a Q sub, and now the medical practice can owe the parent company as much as it wants tax-free, because they're all considered to be one company for income tax purposes. At page 126, I have the beginning of a series of slides of how you get debt in the medical practice so that it is debt with a bank or arm's length entity owed money. One way is that the practice borrows the money and then it gives the loans to Dr. A and B as a dividend, but they have to share the money with the IRS because that's taxable. So at page 127, I have the alternative of Dr. A and Dr. B borrow directly from the bank, and as an employee benefit, the practice entity guarantees the loan and pledges its collateral, and the bank agrees that if there's a default by Dr. A or Dr. B, that it will not pursue them personally until 180 days has gone by. Dr. A and Dr. B now have tax-free or at least tax-deferred money, and they buy investments that are creditor-proof. So I do have a number of variations on that. The last that you can see here. Now, if we go to slide 134, please don't forget Section 199A. You've got a high earner physician doctor. Her taxable income is over $415,000 a year with her spouse. She's not able to take the 199A deduction. If you go to slide 136, if she has children or parents or in-laws that don't have a lot of income, she could have them become part owners of the practice if that's permitted by state law, or if not, you can set up a medical practice management company, let her sign a long-term management agreement. That causes there to be significant value in the management company and a significant cash flow to the management company. You can make this equivalent to what is actually going on all over the country, medical practice roll-ups. And then the doctor can gift medical practice company interests to 678 trusts or directly to trusts to be taxed at the children's level, grandchildren's level, parents, aunts, uncles. Give away enough so that the client's income goes down from above 415 to below 15, and you'll be saving a significant amount of tax dollars, anywhere from $15,000 to $45,000 per year per other family member that you can bring into this. And this is in the 199A book that Marty and I have written. And if you'd like a free PDF copy of that book and you are attending today, those are the two requirements, then we will be glad to send it to you. So Marty, I think that pretty much takes my time. What would you add?
Well, why don't we just recap and give some general comments for asset protection planning for physicians. I'll start and then you can jump in. I think we need to encourage physician clients to start much earlier than they typically do, doing simpler structures, and we've pointed out throughout this discussion how you can build and add on to these structures and these plans as the physician's wealth grows. But we want to get them to start planning as early on as possible. Early in the career, they don't have the claims and suits that they may have later. Early in the career, if they start planning and create some of these structures in simpler ways, and we can decant the trust into more robust, expensive trusts later, they can start to shelter assets and do it little by little each year. And I think that's a great way to do it. So that's clearly one point. We've talked about how you really need to take a very holistic perspective on this. The comments near the end that Alan made on 199A, the comments I made on Roth conversions, the comments that we made in the last session about fraudulent conveyances, issues with the house and what a spouse should or should not own. You really need to take a very big picture. And many clients, not just physicians, will come into our offices and they've heard an acronym or they've heard a planning technique. It seems most typically on the golf course. That's not a safe way to practice. You want this broad approach, because if you take the integrated approach that Alan and I spoke about last week and again today, and you address all these ancillary issues, you can come up with a much more viable plan that is much stronger and harder to pierce. Alan?
Yeah, I would say, Marty, that we have scratched the surface pretty hard here, but that we have not reached all of the things that someone would need to know to successfully plan for a medical practice. We did not talk about the Stark Law, the anti-kickback laws, the state laws that can apply. But we do have checklists in these materials beginning at page 139. So you can go through the checklists. If you're a lawyer and you're going to start doing this stuff, I would say do your best, but get some help the first 5 or 10 you do. We have not been able to cover a lot of the nuances and the tricks of the trade in this webinar. I think I would need about 8 hours to do that. Finally, I do have a book called the Florida Creditor Protection Guide for Physicians. If anyone on the call would like to have a copy of that book, please let us know. Marty, thank you so much for having me on this platform. You do such a wonderful job. Your observations are really good. I love the charitable intro. I'm appreciative to Peak Trust Company for all that they've done for me and my career. They are a fantastic, fantastic organization. So thanks again.
And for all of you on the call, we will post a recording of this and all the materials on shankmanlaw.com/webinars within a few days. So certainly feel free to go back to it or suggest to any of your colleagues or clients that if it will be helpful, they should feel free to use it. Thank you, everyone, and good luck.